Hi all, my name is Kristen Burt and I am the director of our Human Research Protection Program here at Michigan State University, and we are going to start our Zoom session on updates on MSU's Human Research Protection Program and the Institutional Review Board requirements. So just a couple of items regarding the Zoom webinar. If you have any questions throughout the session, please type them into the chat function of Zoom, and at the end of the session we'll address the questions. Any questions that we're not able to answer or that we run out of time, we'll follow up with after the session. Just a reminder, please mute your microphone. So if you have any questions or just to reduce background noise, if you can mute the microphone and then type in your questions through the Zoom chat. And then we are going to get started with the session. So today we're going to talk about two primary topics. First, the Revised Common Rule, which is going to take up the majority of the presentation, and then also the NIH Single IRB Requirement. So with the Revised Common Rule, just to provide an introduction, the federal policy for the protection of human subjects is known as the Common Rule because it's been adopted by a number of federal departments and agencies. A final rule that revised the Common Rule was published in the Federal Register on January 19, 2017, and was amended to delay the effective and compliance dates. So the Revised Common Rule is also known as the 2018 requirements because it was originally scheduled to become effective within 2018. The previous Common Rule is also known as the pre-2018 requirements. The exceptions to the Revised Common Rule is that the U.S. Department of Justice has not adopted the Revised Common Rule yet. So that's one of the major agencies that has not adopted the Revised Common Rule. And then also the U.S. Food and Drug Administration has not yet incorporated the 2018 requirements into their regulations. We do anticipate that the Food and Drug Administration will be incorporating requirements into their regulations at a future date. So with the Revised Common Rule, it became effective on January 21st, 2019. Substantial changes for researchers included what is research involving human subjects, so the overall definitions, exemptions, including limited IRB review, and revised and new exemption criteria. And for non-exempt research, the elimination of annual renewal for some studies, new informed consent requirements, posting of clinical trial consent forms, and single IRB. And these are the items that we're going to talk about today related to updates for the IRB requirements. So the first topic area, the definitions of research involving human subjects. The definition of research was revised in terms of adding specific categories of activities that were deemed not to be research. So the overall definition of research, a systematic investigation designed to develop or contribute to generalizable knowledge, was not modified. However, the addition of categories were added to it to provide clarity regarding activities that were not considered to be research. So those included national security activities, criminal justice activities, public health surveillance activities, and for a reference, there is some draft guidance available on the U.S. Office for Human Research Protection's website related to specific activities regarding public health that's much more detailed, and scholarly and journalistic activities. So we're going to talk a little bit about the scholarly and journalistic activities. So the definition of research was revised to add the categories of activities deemed not to be research. This within the regulations stated that scholarly and journalist activities, for example, oral history, journalism, biography, literary criticism, legal research, and historical scholarship, including the collection and use of the information that focus directly on the specific individuals about whom the information is collected, is not considered to be research under the federal definition within the Revised Common Rule. So studies that are using methods such as participant observation, ethnographic studies, in which investigators gather information from individuals in order to understand their beliefs, customs, and practices, and the findings apply to the study community or group and not just the individuals from whom the information was obtained, fall within the scope of the definition of research of the final rule. So the other area with the Revised Common Rule, that the Revised Common Rule does not include the change that proposed expanding the definition of human subjects to include biospecimens regardless of whether the biospecimen is identifiable. So one of the proposed changes was related to biospecimens, and this was something that went through the commentary on whether it should be incorporated into the revised common rule, where essentially biospecimens in and of themselves would have been considered identifiable. That particular change was not incorporated into the revised common rule. What was included within the revised common rule is a new definition of identifiable biospecimen. So the revised common rule provides that an identifiable biospecimen is a biospecimen for which the identity of the subject is or may readily be ascertained by the investigator or associated with the biospecimen. And a biospecimen is deemed to include private information. So once a biospecimen becomes identifiable, so for example, by being tagged with a name or other information that indicates the person from whom the biospecimen was obtained, then an investigator using that biospecimen is already using something to which the definition of human subject would apply. So if they're obtaining, using, studying, analyzing, or generating identifiable private information or identifiable biospecimens. So this definition is very similar to the current or the previous definition of what's considered to be a human subject and what's considered to be identifiable, relating to whether the identity of the subject is or may readily be ascertained by the investigator or associated with the information. So the next big change within the revised common rule is related to exemptions. One of the big changes within exemptions is a new concept called limited IRB review. So limited IRB review is a new requirement for some of the new exemption categories. So some of the new exemption criteria require that the IRB conduct a limited IRB review to meet the criteria of exemption. So we've been saying this is exempt, but not quite. So it has an added requirement of having a portion of the research being reviewed by the IRB. The limited IRB review can be done through the expedited procedure, and this means that exemptions that require limited IRB review, modifications are required when that modification impacts the limited IRB review criteria. So for example, privacy of subjects or confidentiality of data. As we go through the changes to exemptions, we'll point out the specific criteria of when limited IRB review is required. As we talked about with the modifications being required, typically for exemptions per MSU's requirements, modifications are not required so long as it doesn't alter the exemption determination, change the category to expedited or full board, etc. And within that, the modifications would not be required. However, for the limited IRB review, they are required for certain, when it impacts those specific criteria. So that is a big distinction between the previous exemptions and limited exemptions or exemptions that require limited IRB review. With limited IRB review, annual renewal of limited IRB review exemptions is not required. So that's not different than the current requirement for exemptions, which does not require annual renewal. So at MSU, IRB administrators conduct the exempt review. With exemption criteria that require limited IRB review, an IRB member will also need to review the submission to make the limited IRB determination. So when a project comes in, it's reviewed by the IRB administrators for that exempt criteria, and then if it's one of the exemptions that require limited IRB review, an IRB member would also be assigned to that application. If an exemption criteria involves limited IRB review, this would be communicated to the PI as part of the exempt review process and included within the exempt determination letter. We're now going to go through the exemption criteria and highlight the changes that were made to the previously existing exempt categories. So the first exempt category related to research conducted in established or commonly accepted educational settings specifically involves that for exemption category 1, that research that is conducted in established or commonly accepted educational settings that specifically involves normal educational practices. And the component that's been changed is the additional language that's been added that are not likely to adversely impact students' opportunity to learn required educational content or the assessment of educators who provide instruction. So within this exempt category, that language was added to qualify for the exemption, essentially that it would not likely adversely impact students' opportunity to learn that required educational content or the assessment of educators who provide instruction. And so within the exempt category 1, including most research on regular and special education instructional strategy and research on the effectiveness of or comparison among instructional techniques, curricula, or classroom management methods, that hasn't been modified. The next slide just provides a summary of the change, which we talked about in terms of it being revised to include the criteria that the research is not likely to adversely impact the student's opportunity to learn, the required educational content, or the assessment of educators who provide instruction. The next exempt category, Exemption 2, has been modified with the following language. So research that only includes, so that particular language was added, interactions involving educational tests, cognitive diagnostic aptitude achievement, survey procedures, interview procedures, or observation of public behavior. And then they added including visual or auditory recording to clarify that it can qualify for Exempt 2 even if for example, the interview is being recorded, either by voice or by audio or by video. If at least one of the following criteria is met. So the first criteria, the information obtained is recorded by the investigator in such a manner that the identity of the human subjects cannot readily be ascertained directly or through identifiers linked to the subjects. That had been in the previous exemption. That has not changed in terms of qualifying for this exempt category. The second, that any disclosure of the human subject's responses outside the research would not reasonably place the subjects at risk of criminal or civil liability, be damaging to the subject's financial standing, employability, educational advancement. So that was added to the exemption criteria in terms of the responses would not place the subjects at risk of having that being damaging to their educational advancement or reputation. Or 3, and this is the new category that was added to this exemption, that the information obtained is recorded by the investigator in such a manner that the identity of human subjects can readily be ascertained, so the information is identifiable, directly or through identifiers linked to the subject, and an IRB conducts a limited IRB review to make the determination as required. So in that particular criteria that's cited is related to privacy and confidentiality. So essentially, that third criteria expands exemption category 2 to permit a researcher to obtain information through, for example, a survey or interview procedure where the information is both identifiable and could place subjects at risk of having the criminal or civil liability or be damaging to the financial standing, employability, etc. So it could qualify for the exempt category 2 so long as the IRB conducts that limited IRB review to assure that there's privacy and confidentiality protections in place. So this expands the type of research activities that could be qualifying for exempt criteria, which previously would have required to be reviewed under the expedited or full board type of review. So this expands the type of research that would fall into an exemption criteria. So just in summary, exemption category 2 was revised to clarify that the research cannot include interventions in addition to the educational test, survey, or interview procedures or observation of public behavior. The third criteria is a new exemption criteria that requires the limited IRB review to determine that there are adequate provisions to protect privacy of subjects and to maintain confidentiality of data. Of note, with a particular criteria, it cannot involve children. Related to the third criteria of limited IRB review. And it permits the recording of identifiable data where the disclosure of the human subject's responses could place subjects at risk. So the next exemption we're going to talk about is exemption category 3, benign behavioral interventions in conjunction with collection of information. So this particular criteria may look familiar with you, may look familiar to you. This is a criteria that MSU had adopted previously as a flexibility initiative that we utilized for research that was unfunded. So when the regulation had potentially come out for comment, we had adopted that particular criteria as a flexibility initiative prior to it being incorporated into the revised rule, but with certain limitations. For example, it can only be unfunded. So the revised common rule has now codified this particular exemption category 3. So this would apply to research that is federally funded and doesn't fall into an exception like Department of Justice, and provides that research involving benign behavioral interventions in conjunction with the collection of information from an adult subject through verbal or written responses, including data entry or audiovisual recording, can be exempt if the subject prospectively agrees to intervention and information collection, and at least one of the following criteria is met. So these criteria are going to be familiar. They are essentially replicating what was in exempt category 2. So first, that the information obtained is recorded by the investigator in a manner that the identity of the human subjects cannot readily be ascertained, directly or through identifiers linked to the subjects. The second, that any disclosure of the human subject's responses will not place the subjects at risk. Or the third criteria, that the information obtained is recorded by the investigator in such a manner that the identity of the human subjects can readily be ascertained directly or through identifiers linked to the subjects, and an IRB conducts a limited IRB review to make the determination as required related to privacy and confidentiality. So essentially, an example of this type of exemption would be something like maybe you're having research subjects play a video game and you're looking at their response time to certain type of stimuli, and you are going to be recording the collection of information in terms of how quickly they respond to a certain type of visual prompt in the video game, etc. So it could qualify for this exemption criteria, so long as that the subject prospectively agrees, and then the following criteria related to identifiability, not placing subjects at risk, or the IRB conducting a limited IRB review are met. So the exemption does define, for the purpose of the provision, what benign behavioral interventions are in terms of being brief in duration, harmless, painless, not physically invasive, not likely to have a significant adverse lasting impact on the subjects, and the investigator has no reason to think that the subjects will find the interventions offensive or embarrassing. And provided all such criteria are met, examples of such benign behavioral interventions would include having subjects play an online game, solve puzzles, decide how to allocate a nominal amount of cash between themselves and others. And then the third criteria within the exemption relates to deceiving subjects. So if subjects are deceived regarding the nature or purposes of the research, the exemption is not applicable unless the subject authorizes the deception through a prospective agreement to participate in the research in circumstances in which the subject is informed that he or she will be unaware of or misled regarding the nature of the purposes of the research. So in those instances, you could involve some deception within the particular activity. So in summary, this is a new exemption criteria. This is similar to a version that was previously used at MSU. One of the criteria requires a limited IRB review to determine there are adequate provisions to protect the privacy of subjects and maintain confidentiality of data, and this exemption cannot involve children. The next exemptions we're going to talk about are exemption category 4 regarding, and within exemption category 4, they actually have multiple subparts to them. So we're going to talk about each subpart. So the first is secondary research uses of identifiable private information or identifiable biospecimens if at least one of the following criteria is met. First, that the identifiable private information or identifiable biospecimens are publicly available. So this is similar to the pre-2018 exemption, but expands the scope to permit retention of identifiable private information or identifiable biospecimens, and it allows the exemption to include research with information and biospecimens that do not yet exist when the research study is proposed for the exemption. So in the past, when you're looking at the exemption category 4, the data had to be essentially already created or already available, and that does not have this limitation within this exempt category. So it's been expanded where the data has not yet been generated. So the next component regarding exemption 4, secondary research uses of identifiable private information or identifiable biospecimens if at least one of the following criteria is met. So the information, which may include information about biospecimens, is recorded by the investigator in such a manner that the identity of the human subjects cannot readily be ascertained directly or through identifiers linked to the subjects. The investigator does not contact the subjects, and the investigator will not re-identify the subjects. So an example of this could be if you had, maybe a researcher had an existing data set that was identifiable, that would constitute human subject research. You wanted to use it for another type of research activity, and you are going to record information in such a manner that the identity of the human subjects can't be readily ascertained. So with that, you would still have to assure that you would not contact the subjects and not re-identify the subjects. So the prior exemption was extended to now also cover research with information for which identifiers have been removed when the original collection of information or biospecimen occurs in the future. So again, in the past, it would be something when you submitted the IRB application to the IRB, the data would already have to have been existing. So it had already been collected, it's already available for uses, and you wouldn't be able to use it for that going forward. This particular exemption removes that limitation, so it could be that data is continuing to be generated and could be generated in the future. And it adds that criteria that the investigator does not contact the subjects and will not re-identify the subjects. So this change, this particular exemption criteria regarding secondary research uses of identifiable private information or identifiable specimens, if the research involves only information collection and analysis involving the investigator's use of identifiable health information, when that use is essentially regulated under HIPAA, the federal regulation that protects protected health information. So this is one of the big changes with the changes to the revised common rule, in that in the past, some of these types of projects where if you had identifiable information that was health information, protected health information, that would have required a expedited review. So this is one of the areas in applications coming into the IRB office where there has been a big change, where it previously would have been an expedited review, can now qualify for exemption under exempt category 4. So this can also sometimes be referred to as chart reviews when you're looking at medical records. So this is new. So this permits the exemption when the investigator's use of that identifiable health information is regulated under HIPAA. So under HIPAA, protections include, where appropriate, requirements to obtain the individual's authorization for the future secondary research uses of protected health information, or a waiver of that authorization by the IRB or HIPAA Privacy Board. So even though it's not, it would qualify for exemption, it would still be regulated under HIPAA and the HIPAA requirements. So if the exemption criteria are met, the study would not require a separate research consent. So this would allow you to record identifiable, protected health information as part of your research study and still qualify for exemption. And the last, with exemption category 4, I'm not going to read through this entire exemption, but essentially it's if the research is conducted by or on behalf of a federal department or agency using government-generated or government-collected information for non-research activities, if that research is going to be regulated under certain privacy requirements. So this is a new criteria that applies federal statutory privacy safeguards identified in the exemption provision to both the original collection of information and the secondary research use to which the exemption applies. And the last section of exemptions that we're going to talk about are the secondary research and broad consent, so exemption category 7 and 8. And essentially, these allow for storage or maintenance of identifiable private information for potential secondary research uses if certain criteria are met. And these are new exemption criteria. They require broad consent and limited IRB review. And MSU is still evaluating these exemption criteria, and they are not currently in use. So we're not currently using the exemption category 7 and 8. And just to note, with exemptions and research involving prisoners, that new criteria permits exempting research involving prisoners when the research is aimed at involving a broader subject population that only incidentally includes prisoners. So in the past, if the research included prisoners even incidentally for exemptions, it could not be exempt. The revised rule has added this provision that so long as it's aimed at a broader subject population where it's just an incidental inclusion, then it can still fall within an exemption criteria. So those are the substantive changes regarding exemptions. The next area that we're going to talk about are non-exempt research projects. So the research project did not qualify for an exemption, so now it's undergoing an expedited or full board review. So the first big change is the elimination of annual renewal for certain kinds of studies. So unless required by the IRB, annual renewal is eliminated for expedited research. So these are studies that involve blood draws, or maybe you're doing some type of minimal risk research activity that didn't qualify for exemption, research with children, and a benign intervention, etc. If it's expedited research, annual renewal is eliminated unless it's specifically required by the IRB. The other type of research activity in which annual renewal is eliminated for is research that's progressed to the point that it involves only one or both of the following, which are part of an IRB approved study. So data analysis, including analysis of identifiable private information or identifiable biospecimens, or accessing follow-up clinical data from procedures that subjects would undergo as part of clinical care. So this would be something that the project would likely have been full board review more than minimal risk. And if it progresses to these states, then it could qualify for having annual renewal eliminated. So this only eliminates annual renewal. it still requires submission of modifications. So the requirement to submit changes to the IRB for non-exempt studies is still in effect. So if you were modifying your consent form, adding a research location, et cetera, that would still need to be submitted to the IRB for review and approval. However, there would not be an annual renewal if the renewal was eliminated for a particular project. You would still need to report potential unanticipated problems involving risk to subjects or others, study closure, et cetera. So we would still need to know when the study was complete for these non-exempt studies. So we will still have some kind of check-in to determine if the study is ongoing or whether it could be closed, but there will not be an annual renewal if it meets the particular criteria. So that's one of the big changes related to the revised common rule. The other big change that impacts researchers are changes to informed consent. So within the revised common rule, there's a new requirement that the prospective subject or the legally authorized representative must be provided with the information that a reasonable person would want to have in order to make an informed decision about whether to participate and an opportunity to discuss that information. The revised common rule requires that the informed consent must begin with a concise and focused presentation of key information that is most likely to assist a prospective subject or legally authorized representative in understanding the reasons why one might or might not want to participate in the research. This part of the informed consent must be organized and presented in a way that facilitates comprehension. Informed consent as a whole must present information in sufficient detail relating to the research. It must be organized and presented in a way that does not merely provide lists of isolated facts, but rather facilitate the prospective subjects or legally authorized representatives' understanding of the reasons why one might or might not want to participate. So related to this, within the revised common rule, there was a commentary section that provided some guidance in terms of what this concise and brief summary would consist of. So within that, they had stated that in general, the beginning of an informed consent would include a concise and brief explanation of the following: the fact that consent is being sought for research and that participation is voluntary, the purposes of the research, the expected duration of the prospective subject's participation, and the procedures to be followed, any reasonably foreseeable risks or discomforts to the subject, any benefits to the prospective subject or others that may reasonably be expected from the research, and appropriate alternative procedures or courses of treatment, if any, that might be advantageous to the prospective subject. So they noted that a brief description of these 5 factors would encompass the key information most likely to assist a reasonable person or legally authorized representative in understanding the reasons why one might or might not want to participate in the research, and that the determination by the IRB when reviewing the summary is necessarily project and fact specific. So one size does not fit all. The IRBs may require that somewhat different or additional information be presented at the beginning of informed consent to satisfy the requirement for a concise and focused presentation of key information. They noted that the initial presentation of key pieces of information must be relatively short, that the section of the consent could, in appropriate circumstances, include a summary of relevant pieces of information that are explained in greater detail later in the consent form. And they noted that the information is included at the beginning of the informed consent. The information including does not typically need to be repeated in the body of the consent form. So if you've already stated it at the beginning, you don't need to repeat it. Related to this, one of the things that these requirements were trying to help do is for some consent forms, they can be relatively lengthy. Some of the more biomedical clinical trial types of studies, you can have upwards of a 20 to 30 page consent form, and trying to provide some information up front to the subjects that provides kind of that key information of why they would want to participate in the study. Now, some research projects have relatively short consent forms. You may have a research project that's an expedited study that the consent form is a page long. That concise summary may be incorporated all within that 1 page. So that's something that the IRB reviews as part of when they're looking at the application. So it may not mean that you would need to have to restructure or redo your consent form because it's already short and concise to begin with. So the next area of informed consent that was changed within the revised common rule are some new required elements of consent. So for research that involves the collection of identifiable private information or identifiable biospecimens, the informed consent document must now also include one of the following: So you need to include one of the following statements, either a statement that identifiers might be removed from the identifiable private information or identifiable biospecimens, and that after such removal, the information or biospecimens could be used for future research studies or distributed to another investigator for future research studies without additional informed consent from the subject or the legally authorized representative, if this might be a possibility. Or a statement that the subject's information or biospecimens collected as part of the research, even if identifiers are removed, will not be used or distributed for future research studies. So this is one that we're really emphasizing that researchers carefully consider which option to include, as it can limit that future use of data in the future. So if you indicate the second bullet, the statement that the subject's information or biospecimens collected, even if identifiers are removed, will not be used or distributed for future research studies, that limits what you're able to do for future research studies. So that's just something that when if your project involves identifiable private information or identifiable biospecimens, to carefully consider which criteria is relevant to your research. The next element of informed consent that's now required is that for research involving biospecimens, the informed consent document must include one, a statement that the subject's biospecimens, even if identifiers are removed, may be used for commercial profit, and whether the subject will or will not share in the commercial profit. And then also whether the research will, if known, or might include whole genome sequencing. So for specifically sequencing of a human germline or somatic specimen with the intent to generate the genome or exome sequence of that specimen. And then another required element of consent. So for research that may involve clinically relevant research results, the informed consent document must include a statement regarding whether those clinically relevant research results, including individual research results, will be disclosed to subjects, and if so, under what conditions. So there's a few more requirements within the revised common rule for informed consent. One is related to waiver or alteration of consent. So within the regulations permit the IRB to waive or alter the requirement for informed consent if certain criteria are met. So for example, the research couldn't practically be done without the waiver, it's minimal risk, etc. The IRB could find that the researcher does not need to obtain informed consent from the subjects. So within the revised rule, they've added an additional provision in addition to what the IRB already had to find. The IRB now also has to find that if the research involves using identifiable private information or identifiable biospecimens to waive or alter the consent, the IRB must now also find and document, in addition to those previous criteria, that the research could not practically be carried out without using such information or biospecimens in an identifiable format. So that would be just an additional criteria the IRB would have to determine in granting a waiver of informed consent. The next area related to informed consent is the regulations. The revised common rule now provides an exception for screening, recruiting, or determining eligibility. So the new exception allows an IRB to approve a research proposal in which an investigator will obtain information or biospecimens for the purpose of screening, recruiting, or determining eligibility of prospective subjects without informed consent of the prospective subject or the subject's legally authorized representative if either of the following conditions are met. So either the investigator will obtain information through oral or written communication with the prospective subject or legally authorized representative, or the investigator will obtain identifiable private information or identifiable biospecimens by accessing records or stored identifiable biospecimens. So in the past, the IRB would have had to waive informed consent if informed consent was not being obtained in doing either of these activities. With this new exception, it does not require the IRB to waive informed consent if the above criteria are met. However, just to note that this criteria is not in the FDA regulations. There is specific FDA guidance related to screening tests prior to study enrollment that provides information related to FDA. So the other big change within the revised common rule is that there's a new requirement to post clinical trial consent forms for each clinical trial conducted or supported by a federal department or agency. The revised common rule defines a clinical trial as a research study in which one or more human subjects are prospectively assigned to one or more interventions, which may include placebo or other control, to evaluate the effects of the interventions on biomedical or behavioral health-related outcomes. So this definition is very similar to the NIH definition of a clinical trial. I think they just switched the order of the words. So essentially, if your project meets the definition of a clinical trial that's conducted or supported by a federal department or agency, It requires that one IRB-approved informed consent form that was used to enroll subjects must be posted by the awardee or the federal department or agency component conducting the trial on a publicly available federal website that will be established as a repository for such informed consents. So this could be met through posting on clinicaltrials.gov, or there's a posting which you can do through a regulatory docket. So it must be posted after the clinical trial is closed to recruitment and no later than 60 days after the last study visit by any subject as required by the protocol. And MSU is only requiring this posting for studies that are subject to the revised common rule, so the 2018 requirements, and that are funded or supported by a common rule department or agency. So for example, if you had a industry-sponsored clinical trial that was not conducted or supported by a common rule agency, that would not require posting of the clinical trial consent form at this time because the FDA has not incorporated this requirement into their regulations yet. Or if you had a federally supported clinical trial that was approved by the IRB in 2015, it's currently not subject to the 2018 requirements, that would not require posting of the clinical trial consent forms. And one other area, and we'll talk a little bit more about the single IRB, the next set of slides relating to the NIH Single IRB, is within the revised common rule, there is a requirement, although it does not implement until January 2020, that requires single IRB. So it's a new requirement that any institution that's located in the US, so MSU would be subject to this, that's engaged in cooperative research, must rely upon approval by a single IRB for that portion of the research that's conducted in the United States. So this would apply to non-exempt research studies. So if you had a multi-site study that involved, for example, Michigan State, and then another US-based institution where you're conducting non-exempt human subject research, starting in January 2020, that would require a single IRB. If you had a project in which it was MSU, and then you were working with a collaborator in an international location, it would not fall under this requirement. So they note that the following research is not subject to the provision, so cooperative research for which more than a single IRB review is required by law, so including tribal law passed by the official governing body of an American Indian or Alaska Native tribe, or research for which any federal department or agency supporting or conducting the research determines and documents that the use of the single IRB is not appropriate for the particular context. And we'll talk more about single IRB in relation to NIH. So with the revised common rule, we're going to go through the impact on the changes on new and ongoing projects. So for external IRB studies, so studies in which MSU is relying upon another institution's IRB as IRB of record, that institution's policies and procedures would apply. MSU studies subject to the revised common rule, so the 2018 requirements, would apply to research with limited exceptions that were initially approved by the MSU IRB on or after January 21st, 2019. So for example, if you were going to be submitting an application to the IRB today, your project would be subject to the revised common rule 2018 requirements. It would also apply to projects determined exempt by the MSU HRPP on or after January 21st, 2019, and then studies pending on January 21st, 2019 will be subject to the 2018 requirements with limited exceptions. So exceptions include studies subject to the U.S. Department of Justice requirements only. So the Department of Justice has not adopted the revised common rule yet. So those are still subject to the pre-2018 requirements. And studies that are regulated by the U.S. Food and Drug Administration must also comply with their regulations, the FDA requirements, and the stricter requirement applies. So for example, if you had a project that was funded by HHS and was also regulated by the FDA, you couldn't eliminate renewal because the FDA still requires annual renewal for the project. If a study is not conducted or supported by a common rule department or agency and is required to comply with the FDA requirements, the study must typically comply with 2018 requirements unless otherwise determined by the IRB. So studies that are subject to the pre-2018 requirements, so these are applied to projects that were initially approved by the MSU IRB before January 21st, 2019, that were determined exempt by the MSU HRPP before January 21st, 2019, and studies where U.S. Department of Justice requirements apply. So research that was initially approved by the IRB or determined exempt before January 21st, 2019 is not required to comply with the revised common rule 2018 requirements. The study may be voluntarily transitioned to the revised Common Rule 2018 requirements, but it is not a requirement in terms of having to comply with the 2018 requirements. So what is the transition? So the transition is that a study may be transitioned by the IRB from the pre-2018 requirements to the revised Common Rule 2018 requirements. This must be determined and documented by the IRB, and if a study is transitioned, it must comply with the entirety of the revised Common Rule. So the informed consent requirements, etc. So in what instances may it make sense to do a transition? So MSU considers whether to transition studies on a study-by-study basis at the time of continuing review. So when an application is coming in for continuing review, the MSU IRB is looking at whether to transition the study. That's done in consultation with the PI, and the IRB will consider factors such as the enrollment status. Are subjects still being recruited and enrolled? If so, you would need to revise the informed consent form. So related to consent processes and forms, reliance agreements. If we have a reliance agreement in which we have agreed to comply with the pre-2018 requirements, we would look at whether or not that would impact the transition. Review level. So for example, if it's more than minimal risk, we are not transitioning those types of studies. Funding, and then regulatory oversight. So typically the following types of studies will not be transitioned. So studies regulated by the FDA, studies subject to oversight by the Department of Justice, as those have to comply with the pre-2018 requirements, studies that involve reliance agreements where MSU is serving as IRB of record, studies with subjects enrolled with active recruitment unless the IRB determines that transitioning is appropriate in consultation with the PI. In those instances, the informed consent would need to be modified to meet the revised requirements, and studies that are more than minimal risk or otherwise require full review, and studies funded by a common rule department or agency. So it's a lot of information about the revised common rule. Just wanted to go through a few FAQs related to the revised common rule, just questions that we've been seeing as this has been implemented. So the first is related to how does the revised common rule impact studies ongoing before January 21st, 2019? So like we had talked about as part of the transition, the study that were initially approved by the MSU IRB or determined exempt before January 21st, 2019 is subject to the pre-2018 requirements unless the MSU IRB transitions the study to the 2018 requirements. There is not a requirement to transition to the 2018 requirements. It can be voluntarily transitioned if it meets those particular criteria. And MSU, again, plans to consider that on a study-by-study basis at time of annual renewal. And the PI is consulted about whether to transition the study. Another question that we've had is that if you have a non-exempt study approved by the MSU IRB before January 21st and it will expire soon, do I need to submit a renewal? Yes. The study is still subject to the pre-2018 requirements and annual continuing review, so a renewal must be submitted to continue conducting research with human subjects. When you do submit that renewal, the IRB will consider whether to voluntarily transition the study to the 2018 requirements with input from the PI. Only if the study is transitioned to the 2018 requirements and it meets the requirements for eliminating annual renewal will the requirement to submit a renewal be removed, and modifications are still required. So how do you know if your study is subject to the pre-2018 requirements or 2018 requirements? So approval or determination letters that are issued by the HRPP and the IRB on or after January 21st, 2019 include this information on the letter. So if you have any question or you're not quite sure, it'll be on your determination letter. And have consent templates been updated with the revised common rule? So yes, the consent templates have been revised to incorporate the revised common rule requirements, so those additional elements, the key concise summary, and those are available on the HRPP website. And there's also additional resources available. We have a revised common rule page that specifically has information related to the significant changes, more detailed information, FAQs, guidance, revised templates, etc. So that's available for assistance if you do have any questions, as well as contacting our office if you have questions about any of the processes. So the last area that we're going to touch on is the NIH Single IRB Requirement. So this one was actually implemented in 2018, but we're trying to provide more outreach and education about this requirement with NIH for single IRB review. So use of a single IRB is required for all domestic sites participating in multi-site studies involving non-exempt human subjects research funded by NIH, where each site will conduct the same protocol with limited exemptions. So the key information for this is that if an NIH proposal may require a single IRB, please contact us, the MSU Human Research Protection Program, as soon as possible. So with the NIH requirement for single IRB, the NIH requires a single IRB plan at time of proposal. So this is a little bit different than what with NIH, typically you're going through the IRB process at just in time in terms of submitting an application to our office. However, with single IRB, at time of proposal, you need to include a single IRB plan. And this plan requires the name of who will be the single IRB, an indication that all identified participating sites have agreed to rely upon the proposed single IRB, among other items. So that's why it's so important to contact us early, as this discussion can take time between the institutions in terms of selecting that single IRB. So what does MSU require for the single IRB? So the MSU PI contacts the MSU HRPP to identify the single IRB. The MSU HRPP must agree to the selection of the single IRB, and that selection of the single IRB is dependent upon factors such as complexity of the study, expertise, number and type of sites, location, risk level, resources. So for example, if we had a study in which maybe MSU is going to be the primary awardee, there are 20 other sites, it's being conducted across the US, it's more than minimal risk, there's some type of clinical procedure, that would be something that we would likely look at using a commercial IRB. So that is one of the areas in which within the single IRB, that is one of the options in terms of using a commercial IRB, which would be an IRB that's not affiliated with a particular academic institution. So for example, Western IRB for the review of the study. So that's why we really recommend to please contact us as soon as possible so we can help walk you through that decision process. So what do other institutions require for single IRB? So it depends. So you really want to contact those other institutions as soon as possible, or have your colleagues at those institutions contact their IRB office to determine what their process is for selection of the single IRB. So it may vary. So again, that's something you want to do early. And then, are there costs associated with the single IRB? So there may be. So if MSU is serving as the single IRB, MSU does not charge a cost. So typically when you look at IRB review for an NIH proposal, that's not incorporated because it's included as part of the F&A rate, the indirect cost. However, with the single IRB, NIH has allowed for costs to be charged to a grant for that single IRB review. So MSU does not charge a cost. However, if an independent IRB is being utilized, there are fees charged by the independent IRBs, and those may be charged as a direct cost to the grant. Another institutional IRB, single IRB, you want to check with that institution whether they have costs related to the single IRB requirement. And this is, again, important to determine early, as this can impact the study budget. So for example, one of the things that the commercial IRBs will help with is trying to estimate how many modifications may you have, certain things, because there's charges related to those. So that's just something that if you do have something that's a single IRB and it's going to be another institution, just to be familiar with and to check on related to costs. So other training opportunities. So related to single IRB, one of the events that we are coordinating is having the Western IRB come to campus on May 14th, 2019. So we're going to be having a representative from WIRB. We'll be conducting an on-site training with question and answer period, and we'll be doing it both live and through Zoom. And the session will be available again through webinar or live. And WIRB is one of those external independent commercial IRBs that MSU does have an institutional agreement with. MSU can rely upon WIRB for IRB review of certain studies, such as multi-site research or studies that must comply with the NIH single IRB requirements. It could be an industry-sponsored clinical trial. It could be an NIH single IRB requirement. We've had instances where another institution is the primary awardee and they're utilizing a commercial IRB like WIRB. Registration is required and is available through the Ability Learning Management System. So if you are interested, please visit our hrpp.msu.edu webpage, go to the events, and then you can click the link for registration information. So with all this, that's a lot of information. So we always like to end with contact information. please contact us with questions. If you have any questions about the revised rule, NIH Single IRB, or anything else, please feel free to contact us either by phone. The phone number provided is our main office number, and then also by email, either to the IRB office or our compliance office. And with that, we will transition over to questions as part of the session.
Thank you so much, Kristen. One of the questions that we have from online is regarding biospecimens that are not already obtained at the start of the research. Does this mean you can have a project where you are obtaining survey-based data and also draw a blood sample to look for particular genetic characteristics like a polymorphism, and the study is exempt from IRB review?
Yep, that's a great question. So with the definition of human subject, part of the component to it is if you are doing any interaction or intervention with human subjects. So that interaction or an intervention, like a blood draw, would mean that they're human subjects, or if you're looking at their identifiable biospecimens, so something that's already been drawn and collected, sitting on the shelf. So what the exemptions are really looking at are things that have already been collected. So typically if you're going to be doing a blood draw as part of the research proposal, that would fall within an expedited category for review. Now if you're working with a collaborator who has samples that have already been collected, or maybe they're being collected for another research purpose, it could potentially qualify for exemption. But I would recommend, if you have any questions for a particular research project, please contact us.
Thank you. The second question you touched on later in your presentation was asking for confirmation that all studies that were approved prior to January 2019 still stand, the approval stand.
Yes, yep, so that is one question that we do get frequently, is that prior to any projects that were determined exempt or approved by the MSU IRB prior to January 21st, 2019 fall under the pre-2018 requirements. So you do not, at your upcoming renewal, have to do anything differently in terms of complying with 2018 requirements. Essentially at that time, the IRB will look at whether it makes sense to voluntarily transition to the 2018 requirements, and again, that's in consultation with the PI. So in some instances where that may make sense is if you had a study that was expedited and now can qualify for exemption, you may want to transition the study to an exempt category, or if it's a study in which it's unfunded, it's under data analysis only, you're still looking at identifiable data, transitioning it to the 2018 may make sense in terms of eliminating annual renewal. But that, again, if your research was approved prior to January 21st, 2019, either approved or determined exempt, it falls under the pre-2018 requirements unless we do the voluntary transition.
Thank you so much. If anyone has any other questions, please write them in now into the comment box.
Thank you.
All right, if there are no other questions, thank you so much.
Yep, thank you so much for having me. Have a great day, everyone. Thank you so much for joining us.